Hello guys, we are going through landmark judgment of Supreme Court in this series. These judgments which we are talking about shape our world. When I say world, India, they talk about rights and liabilities which we enjoy in India. Okay. And this particular issue is about pretrial detention. And it would not wrong to say that it is the basis of human rights, because we have to understand there's a difference between the accused and the conviction, right? Accused, like, are the person, they are the part of the society, right, the way we live in. And it may happen that someone is wrongly implicated, or falsely put under the trial. Anything could be happen, like, till the person is not convicted, it's not a criminal, right? So, and this particular thing is all about the pre-trial detention. And in the case law which we are going to discuss is around Husainara Khatun versus Home Secretary, State of Bihar. It is the period of 1979. This case laws. Yes. Let's understand the pretext of this case, because it's important to understand in which environment and the pretext this whole thing happened. So, an article was published in Indian Express unveiling the presence of large number of men, women, and children behind the bar, awaiting for their trial in the state of Bihar. So, and Husainara Khatun was one of such prisoner. So, after this article, Advocate Mrs. Hingorani filed a writ petition of habeas corpus before the court. When I say court, means like Supreme Court, because we are talking about the landmark judgment of Supreme Court. Under Article 32 of the Indian Constitution, it stated that a large number of men and women, including children, were in jail for years awaiting for the trial in the court of law. That the offence, even if proved, would not warrant a punishment for more than a few months. Which also, and this particular petition also, demanded release of 17 such trial prisoner, which she was able to identify based on the articles and other things. So the question of law was, fundamental rights of accused and also the duty of state, as expressed in Article 39A of the Constitution concerning free legal service to poor and denial of which in delayed trial system would also mean the denial of right of an individual's life and personal liberty, as said in Article 21. So what happened, like what Supreme Court observed, let's see that, okay. Supreme Court observed that it is due to inefficient system of bail, which is keeping justice beyond the reach and the grasp of poor, okay, and worked only into the advantages of wealthy. Because we know, like, wealthy people can easily go and get access to good lawyers, and they able to give the bail amount, and they get free. But for the poor people, they cannot pay the amount of bail fixed by the court, because they don't have money, and not many different scenarios. So this complete system of the bail is flawed. So court said it is better that we abandon the old practice of releasing only against the bail with securities, and even it's promoted or endorsed the bail on personal bonds without monetary obligation, so that poor can also avail this facility of bail. Court also held that it is a constitutional right of every accused person who is unable to engage a lawyer and secure legal services on account of reasons such as poverty, indigence, or incommunicado situation, and the state is under a mandatory obligation to provide lawyers to such accused person if the circumstances of case demand so, for the need of justice. Of course, like, accused person does not want and can object to it, but it's the state's obligation to provide them. It's mandated. And by doing this, Supreme Court give the very wider interpretation to Article 21 and emphasize upon the speedy trial and free legal aid for the effective administration of justice and equality among citizens. On the basis of above, reasoning which court have given in this particular case, pronounced the release of until trial prisoners on personal bond without any monetary obligations. So this is not the end of only cases which came up to the Supreme Court or or in the different other courts of the country about the situation of the plight of accused who are under trial, and majorly the poorer section of the society. And these cases have like highlighted the deficiency or deficiency in the bail system which we have. As a result of such cases, Code of Criminal Procedure was amended to insert Article Section 436A in 2005. Article 436A states that if an adult trial be detained in jail was half the maximum punishment that could be awarded for the punishment, that he could be released on bail on the basis of personal bond as the security for bail. Which means that let's say someone has done some offense, and if it's reaches whatever the offense is and whatever the punishment, let's say punishment for that offense is 4 years, and if the person is in jail for already been in jail for the 2 years, even though the trial is pending, that person could be released. Obviously, like there are some safeguards inserted into this, saying that if the public prosecutors provided a reasoning after hearing the public prosecutors, and if the court feels fit, and writing those reasoning in written, can still keep the accused in jail, but not beyond the maximum period of imprisonment provided for the said offense under the law. Let's say that as in the earlier example, we said up to 4 years, if that's the maximum which could be possible, and if the accused is already into the jail for 4 years, and beyond that, even though the trial is pending, court cannot or authorities cannot put them behind the bar, and they have to leave this. So that's how the system evolved over the period of time. So please share your views. What do you think does the plight of accused, particularly the poorer section of the society, does it improve? Like looking at the ground level, like do you think that still there is a lot improvement is required? What's your thought? Like, do put that in the comment. If you like this type of content, then please like and subscribe.